What are your days like now?
Well, actually, I'm pretty busy. I'm uh, I'm helping Judge Burton out as the ombudsman for the Wayne County Probate Court. I chair the Mental Health Diversion Council. I'm the chairman of the foundation board at Eastern Michigan University. I serve on the board of directors of Southwest Solutions, now my side, which provides mental health services to adults and children. And I'm assisting other states in developing laws to improve their system.
Judge Mack, you didn't retire. What is your wife saying? You didn't retire.
Yeah, she's disappointed in my retirement skills. And I'm still working with the Supreme Court on developing strategic planning for the state of Michigan. So,
Oh,
yeah, so
you got to understand the definition of retirement.
I'm not doing well. The As you probably read the governor's talking about a bunch of new bills for juvenile justice,
Yes.
and that's I'm not sure what the impact of that's going to be, but it it is a big deal in a lot of ways. In one particular way, which may discourage parents from taking action, is that until today, uh, if a parent went to juvenile court to have their child determined to be incorrigible,
Mm-hmm.
the parent was responsible for paying all the costs associated with it, including housing, and that's expensive. So what's happening is parents were racking up these huge bills all across the state, and in most cases, the parent could not pay the bills anyway. So the collection rate by the court of these fines and costs were minimal, less than 10%. But it was still acting as a barrier. So the legislature has eliminated that. And so now the parents aren't charged for that cost of service. So I'm hoping that will encourage parents to uh, feel freer to take this action. And so the main action now is if you can have a child determined to be incorrigible and the child can be placed in a residential setting. Yeah, I think AOTs not doesn't really apply because what AOT is basically court ordered outpatient treatment, and the consequence of non-compliance could be rehospitalization, but that's about it.
Gotcha.
But for minors, the parent or guardian has a right to consent to mental health treatment for a child, even if the child is resistant. So you don't need a court order. The, the challenge is getting someone to consent. Once you're an adult, the only consent comes from the adult. And that's where AOT comes in because the judge is basically overruling the individual's position. But then for minors, the judge doesn't need to overrule the minor because the parent can overrule the minor. So what's happening in now Oakland County, the community mental health system there,
Mm-hmm.
they had developed a program. They're one of two in the state that have done this. They use what's called a sequential intercept map. And what they do is they identify each step along the way where uh, treatment can be provided for a child. And like intercept zero is before the child has any connection with the criminal justice system or anything like that, or delinquency, before court involvement. Uh, and then at that point, they take steps to see if they can keep the child from going further. And then for those who do go further, like for those who actually end up in court,
Mm-hmm.
and there's a process there to try to, again, assist them and correct the problem. And I think Intercept 4 is when they're leaving the court, and then Intercept 5 is when they're leaving residential treatment. So it's aimed at providing a continuum of care. And one of the key aspects is um, they are, in Oakland County anyway, uh, you don't have to be Medicaid eligible to get this service, and that makes a big difference. So Oakland County is doing that. Washington County has done similar mapping exercise. I don't know how far they gotten with it, but those are the things. It's really a matter of expanding the services so parents aren't frustrated. I mean, I know a woman who adopted a child, and the child was uh, really a problem, and as an adult has ended up in and out of jail. But this child would like break and enter the homes of family friends of this woman, and it was so you're showing you really these out of control children. What do we do? And I think from uh, behavioral health and juvenile justice, it's like get them into care as soon as possible and don't let things fester. The longer we wait, the more difficult it is to try to correct the behavior. It's really an education issue too.
Okay.
So I think, I mean, that is a problem with video. I think that's something I think at that point, what the mom can do is say, I'd like to have this hearing in person.
Okay.
And you have a right to have it in person.
Okay.
So Zoom works for most people, but in a situation like that where there's risk of domestic violence, you don't want it to be by Zoom. And you don't want the abuser in the room with the abused. It's not good. And when you get the notice of hearing, I would contact the clerk immediately. Look, this is a domestic abuse issue. Uh, this needs to be in person. Well, I think getting into treatment is critical, and then if the child is non-compliant, I mean, it just increases and ratchets it up. A child can be determined to be incorrigible, and in that case, there's a residential placement for the child. So I know these things are challenging. I know that even for AOT by family members, family members are reluctant to file these petitions until things get too bad. But really, they need to file sooner. And we have a mediation system now so that it's less, you don't have to actually be in court necessarily. So for adults, it works. But for children, I don't know that mediation would be effective. Yeah, the parents, and perhaps we need to, there may be some statutory requirements or some statutory changes needed, but typically what parents do who are educated about it is they file a petition for incorrigibility with the probate court, actually with the family court now. And that's easy to do,
Okay.
but not many people know about it. But that's the route. And at that point, the system becomes engaged. Um, what I like about Oakland County is they do the engagement before you go into the juvenile justice system.
Okay.
So ideally, um, each county would engage in a mapping exercise to lay this out. So this requires coordination by the community mental health agency as well as by the court. They both have to get together. So, um, so they're doing it in Oakland County without any statutory changes, and the county is providing funding for that. Now, what you could argue is that the legislation should require that all counties, CMHs, and courts combine to engage in the mapping exercise and that the state provides sufficient funding to support all children, not just those who are Medicaid eligible. I mean, that would be, if we can get that done, that'd be a big deal. And in that situation, the issue should be brought to the attention of the court through a petition. And I think that's appropriate to do that.
Okay.
But I think the better option is to use the SIM model, sequential intercept model, and it's a sequential intercept map. And you need to get the mental health system and the court aligned. I can tell you that I'm actually working with the state of Illinois now on improving the mental health system as it relates to adults.
Okay.
I haven't covered the children yet, but that's an important area because a child with mental illness who's left untreated until they're an adult is probably really a problem.
It is.
The mental illness doesn't get better without treatment, but it does get worse without treatment. So, but I think there should be a process to bring this to the attention of at least the community mental health system, and the community mental health system to engage, and also with the courts if necessary. It would depend on the level of. You'd have to figure out, how dangerous this is.
Okay.
The higher the level of danger, you want to go right to court, as opposed to a lower level where you try to handle it through the mental health system. But the mental health system has to be responsive. Well, I think it's a good idea. I'm not sure how you would implement it necessarily, but I think it's a good idea. It provides cover for the person who's making the report, for example.
Okay.
And that might be important to that person. So I think that's a good idea. John, I would concur with that. I mean, how we address it doesn't really matter, but I think updating the federal laws to recognize that as a problem would be important. I mean, it really, children who are behaving like that, they have issues that need to be addressed. And while we don't really, it's not really titled a mental illness at that age, it's a behavioral disturbance.
Okay.
So the system should respond to that. And there should be an easy way to engage the system. It shouldn't be complicated. And the funding should be there for children, regardless of Medicaid status. That's really an important consideration because a lot of people, adults and children, who have an issue that requires treatment can't get treatment because they don't qualify for Medicaid. They're not poor enough. So it's sort of like our system says, well, as soon as you become poor enough, we'll take care of you. But until then, forget it.
Right.
And of course, if you do become poor enough, we can help you. You have to stay poor or you lose your coverage. So I was on the Mental Health Commission in 2004 in Michigan, and we argued for permanent qualification. So if a court ordered mental health treatment for you, then by definition, you were eligible for mental health treatment, and that treatment eligibility was permanent, even if you got a job. Okay. Even if you had lots of money. It's not income-based. It's not, this is a health problem. Well, I think there's an ability to expunge. I think automatic is a little bit risky.
Okay.
I mean, if you have a child who goes through therapy and it wasn't, the level of risk was not too high, but they emerge from the process in good shape and doing well, and they stay well in adulthood for some period of time, then I would support expunging that. But if you have someone where treatment's not working and then they become an adult and leave the juvenile system, I would not expunge those. So I think I would say I do not support automatic expungement, but I would support expungement under certain circumstances. So you have to have, you need a court hearing.
Okay.
But for example, in Michigan, if I enter an order for mental health treatment and hospitalization, but enter an order for hospitalization, the person goes on a list and they cannot acquire a weapon. And that they're on that list permanently, unless a judge removes them from the list. So, so in my 25 years on the bench, it came in front of me twice. One time, it was because the husband, well, the husband was on the list because of a very old hospitalization, and he wanted to be off the list because his wife was starting the daycare business, and he couldn't be a part of that because he's on this list. So he didn't want to be off the list to get it done. He wanted to get off the list to do the daycare thing. So I approved that. And another one was a man who had a depressive episode 20 years ago and was doing fine. He was not in treatment. And so I took him off the list. But, you take a look at each one and decide whether this is a good one to come off the list. So I think it needs to be discretionary, but not automatic.